Mr. Dunlap, it appears that you were active in Maine against a ballot initiative legalizing same-sex marriage. Is that true?
I believe you're referencing simply an op-ed that I published that expressed at the time my disagreement with the theft of political signs through that
If you were not active against that ballot initiative, why would you be engaged about political signs?
In one of the most telling exchanges on Capitol Hill, Senator Sheldon Whitehouse confronted Mr. Dunlap over his past views, writings, and affiliations regarding same-sex marriage, abortion rights, and the influence of partisan groups in shaping legal careers. What began as a seemingly technical line of questioning quickly escalated into a deeper exploration of judicial philosophy, political neutrality, and whether nominees can separate their personal beliefs from the impartiality required in public service. This debate is not merely about one man's past statements. It is about the larger struggle over the courts, the Constitution, and the lives impacted by decisions on marriage equality, reproductive freedom, and the role of faith in law. To understand why this confrontation matters, we must unpack the exchange piece by piece, situate it within America's broader cultural and political battles, and ask whether neutrality is possible in a climate where every legal stance signals broader ideological commitments.
Mr. Dunlap, it appears that you were active in Maine against a ballot initiative legalizing same-sex marriage. Is that true?
I believe you're referencing simply an op-ed that I published that expressed at the time my disagreement with the theft of political signs through that
If you were not active against that ballot initiative, why would you be engaged about political signs?
I lived in the area in which I observed that political signs are being stolen, and in my view, the First Amendment
That was
there.
in your testimony to us is that was only about political signs, that you did not take an active part in the same-sex marriage ballot initiative.
I did not play a part in that ballot initiative, no.
I'm sorry? Say
I
again?
did not take a part in that ballot initiative, no.
Even as a advocate? I mean, you weren't, when you say you did not take a part in it, what exactly does that mean?
I had no active role or participation in any campaign relating to that.
Did you say that gay marriage would affect our rights under the First Amendment, freedom of speech, and free exercise of religion?
Again, the position that I was taking there was that in the context of that ongoing political campaign, that there were thefts of political signs, and I expressed my disapproval of that. The political speech is central to the First Amendment.
But you also said that allowing gay marriage would affect our rights under the First Amendment, freedom of speech, and free exercise of religion. So you at least took that public position, did you not?
I did.
Which is a little bit different than taking no public position. You also supported a Maine bill entitled An Act to Allow a Wrongful Death Cause of Action for the Death of an Unborn Child. Could that statute be applied to a woman seeking an abortion or to a doctor providing an abortion?
So that proposal would have brought Maine's law into line with that of all other New England states. It does not apply in the context of abortion. It would have given grieving parents the opportunity to recover for a tortious death, as that was defined
But not
in the
one
statute.
provided, not one related to the woman obtaining medical care.
Again, that statute exists throughout New England except for the state of Maine, and it has not affected abortion rights in those states.
When you were in law school, you interned for a nonprofit whose purpose is to oppose women's reproductive rights and to oppose marriage equality and to oppose the right of LGBTQ couples to adopt children. Did you intern for that organization because you supported or shared those views?
I was a Blackstone Fellow. I participated in a program that offered training in First Amendment law, draws from a wide variety of law schools across the country, and offered the opportunity as well for an internship. I spent my internship that summer as a research assistant for Professor Garnett at the
Do you have
University of Notre Dame.
choices in what group you interned with?
I applied to that for that job.
You
yes.
applied for that job for that group that has as its purpose to oppose women's reproductive rights, to oppose marriage equality, and to oppose the right of LGBT couples to adopt children, correct?
I applied for the Blackstone Fellowship, which is run by ADF, which is a highly successful law firm.
And you chose to do that internship at ADF, correct? You weren't forced there, you weren't driven there, this was your choice to do that. You picked that internship and you picked that organization.
That's correct.
And yet you say that you had no view on the same-sex marriage question in Maine, even though you devoted yourself in law school to interning for an organization that opposes same-sex marriage.
I don't believe I ever testified that I did not have a view. I said I did not participate in the campaign.
Yeah, well, your version of participate seems a little squirrely to me when you're actually writing op-eds related to that question. I will leave it there because my time has expired, but I hope that we'll get real answers, Mr. Chairman, to our questions for the record. I've been told that Republican members are telling witnesses that they actually don't need to answer questions for the record. And we've seen sham answers to questions for the record. This committee is spiraling away from being the least bit responsible with respect to our oversight. And I would hate to think that QFRs no longer matter in the Judiciary Committee of the United States Senate. Thank you.
The exchange between Senator Sheldon Whitehouse and Mr. Dunlap exemplifies the tension between judicial candidates attempting to present themselves as neutral arbiters of law and the Senate's responsibility to interrogate their pasts, writings, and affiliations. Whitehouse's line of questioning zeroes in on three central issues: Dunlap's commentary during Maine's same-sex marriage referendum, his support for a wrongful death bill affecting unborn children, and his internship with the Alliance Defending Freedom, ADF. Taken together, these threads weave into a much larger tapestry of judicial credibility, public trust, and the entanglement of religion, politics, and law in the United States. At first glance, Dunlap's insistence that he was not active in the same-sex marriage campaign might appear to absolve him of political entanglement. Yet, as Whitehouse cleverly underscores, the absence of campaign work does not equate to the absence of advocacy. Writing an op-ed, particularly during a heated ballot initiative, is itself a public advocacy. When Dunlap stated that allowing same-sex marriage could negatively affect First Amendment rights, including freedom of speech and freedom of religion, he was not just lamenting the theft of political signs. He was framing marriage equality as a constitutional threat, planting his stake firmly in an ideological debate. This is where Whitehouse's prosecutorial style shines. He reframes the supposed neutrality of Dunlap's actions, exposing that even a passive choice like writing an op-ed is, in reality, a public declaration of political belief. The senator's larger point becomes clear. Neutrality is not just about what one refrains from doing in campaigns, it is about the ideas one chooses to endorse, even casually in public discourse. The second layer involves Dunlap's support for legislation granting a wrongful death cause of action for unborn children. On its surface, the bill aligns Maine's law with neighboring New England states. Dunlap defends it as a simple matter of legal consistency, pointing out that other states have such laws without threatening abortion rights. But Whitehouse sees through the framing. Laws concerning the unborn are rarely neutral. even if unintended in their consequences. They carry symbolic weight, signaling sympathy toward a worldview that treats fetal life as legally equivalent to born life. Critics of such laws warn that even if abortion is technically exempted, the symbolic elevation of fetal rights inevitably feeds into broader political campaigns against reproductive freedom. Dunlap's insistence that the law had no bearing on abortion rights may be legally accurate, but politically it situates him within a conservative legal framework, a framework Whitehouse believes is relevant for a nominee who might one day rule on such questions. The third and perhaps most explosive point raised by Whitehouse concerns Dunlap's internship with the Alliance Defending Freedom. ADF has built a reputation as one of the most prominent conservative Christian legal advocacy groups, opposing abortion, same-sex marriage, and LGBTQ adoption rights. Dunlap frames his involvement as participation in a Blackstone Fellowship, which he describes as an opportunity to gain First Amendment training. But Whitehouse dismantles that defense by pointing out a crucial detail. Dunlap applied for the internship. He was not assigned to ADF, he chose it. That choice, as Whitehouse emphasizes, is not a trivial matter. Law students have countless opportunities for internships, clerkships, and fellowships. Selecting an organization whose explicit mission is to oppose reproductive and LGBTQ rights is, in itself, a declaration of alignment with those values, or, at the very least, a willingness to benefit from institutions that advance them. Dunlap's claim that he was simply seeking academic experience sounds hollow when placed against the backdrop of ADF's well-known ideological agenda. This is where the tension between legal training and political signaling becomes unavoidable. Dunlap may genuinely believe that he sought the internship for its First Amendment focus, but the reputational and ideological implications of that choice cannot be erased. As Whitehouse puts it, it looks squirrely to claim neutrality while simultaneously applying to an organization that has dedicated its existence to opposing equality. This exchange may seem like just another partisan clash in Washington, but it holds lessons far beyond the walls of the Senate. It reminds us that neutrality is not just a word invoked during confirmation hearings. It is a standard that must be earned through consistent choices. When nominees downplay their past advocacy, and when senators fail to demand clear answers, the public's trust in the courts erodes. Senator Whitehouse's sharp questioning of Mr. Dunlap is less about one individual and more about defending the integrity of the judiciary. As citizens, we must remain vigilant, asking ourselves, do we want judges whose records show neutrality in action, or judges who claim impartiality only when under the spotlight? The future of constitutional rights, from marriage equality to reproductive freedom, depends on how we answer that question.